Good morning. Good morning. Thank you, Tay Bay. Hold on. I'm gonna sneeze. Excuse me. I'm so sorry. My allergies are acting up this morning. I've been trying to come down with a cold or whatnot. I apologize for that. I was right as I was about to come on, the sneeze hit, y'all. Thank you, Tay Bay, for becoming a new member. Thank you so much. Good morning. Good morning, James. Oh, I'm so sorry, y'all. My nose is running. I know I'm sounding all weird. Um, So right now, what we got going on, I gotta tell y'all about it. Uppity and um, Brooke are going at it right now on YTCs, and that's because Uppity was going at Exposed TV, and Brooke jumped up there and went at Uppity, and I'm like, whoa, sweet baby Jesus. Uppity was showing where she was walking to, showed the street signs, said, come meet me. I'm sorry, but I ain't fighting in New York. I ain't going to jail in New York. Uh-uh. She in one of the boroughs too. I ain't going to jail in New York. Good morning, the hood table. I would say so. I was trying to watch Lemons last night, y'all, and I fell asleep. I fell asleep. You know what I'm saying? I fell asleep, and then I woke up this morning. I was trying to watch it, but UTC it was going down in UTCs this morning, y'all. And watch, YouTube cameras. It was going down in her live this morning, and my dog. I swear, he thinks he has to get under the cover and be right beside me at all times. But so anyway, it was going down over there. Now we all know about Exposed TV showing Lolo's text messages, right? And in those text messages, she said that she misses Ness, right? And some people are asking Lolo, this was said after the sit down at Leo the Lioness's. And they're asking her why. But I'll say this in my opinion. I do understand where everybody's coming from. Why would you miss somebody that's done read you to filth and talked all kind of mess about you? At the same time, if you've been friends with somebody for a long time, you can still miss that friendship. You know what I'm saying? But I don't know if I would ever, me, myself, and I want to go back. Because I'm going to say this once you, like, it's one thing, like, me and Uppity made up, right? It's one thing for me, like, me and her, it wasn't really nothing serious, in my opinion, right? Me and Uppity were never friends from the beginning, right? And we made up, we had a good little, a thing, um, because here's the thing about me. I got a very kind heart. If a lot of y'all know that, and when somebody's upset, I don't like it, or if I see something that could hurt somebody. So I was over there at Pretty Chocolate Girls, and Miss Uppity was having issues, with her stove, and I was asking her about her box in her house. The what do you call it? The to see if her breakers had enough power to supply the stove without it, having a problem. And I saw that in her breaker box, she only had 110s. She had a few 15s, few 20s, but I didn't see any of the big boys. And I was like, you need to make them upgrade that. And so I was worried that that house might have a problem. So I was telling her about it. And, from there, we kind of had a little bonding moment, right? We had a good little conversation. Because I don't want to see anybody have a fire in their home because of something I could have helped prevented and maybe reach one, teach one, and, tell her about it so that she could tell her, the maintenance mans or whatnot to come do something about that, to upgrade that. Because a lot of these older houses, a lot of people don't know this. If you've got an older house that was built in like 1920, 1930, 1940, even when they upgraded the box, they may still need to upgrade and put you in higher voltage um, breakers, right? Because it was steadily, she said it was steadily throwing the breaker when she used her stove. Well, yes, that can be a problem with the stove itself, but it also can be a problem where the breaker's not big enough or strong enough to handle the stove. They may have more than one thing hooked to that breaker. Um, this is a reach one, teach one moment. I'm using the mess as a message. So a stove should be on a 220, right? It should be a 20 or a 40 breaker by itself, right? It should be by itself on its own breaker. That's just like your dishwasher, your refrigerator, your anything that's a big appliance that pulls a lot of power. It should have its own breaker. If people are doing wrong to you, that could cause your house to catch fire. But I saw that Uppity and Brooke was going at it, and she said, Uppity said that exposed TV was the Brooke in the situation, and she was the Rita. That's what she said. Now, exposed TV never jumped up there herself, as far as I know so far. It was Brooke talking for exposed, but exposed herself didn't pop up there that I know of. Sorry about all that, y'all. My nose is just running. This is your morning reminder to take your medication. Please take your morning medication. Now I was over there. I was scrolling real fast through lemons, right? And I did see that Lady Law popped up there, and I saw that Just Krista was on the panel almost all night long. And so I'm guessing that their situation is they're still chill. Um, I don't know if they're back in a relationship or not. Um, you know, I don't know if anybody told Lemon, about. I mean, they did tell Lemon about some of the things that was said over at Buddy Lee's, but then we got to wait on Buddy Lee Friday. Hey, Happy Life. Hey, Ray. Good morning. Good morning, James. Did I say good morning, everybody? Y'all, I'm half sick, so I'm so sorry if I missed anybody this morning. Good morning to the cloud watchers, those getting ready for their day right now. Thank you. You could be anywhere watching while you're getting ready for your day or going to work or coming from work, but you decided to be here. So thank you for being here. Well, I know that Rex was Rex and Lemon ended up making up, and I don't know if they started going back at each other again. Because you know how Rex is when he gets to drinking and he starts hitting panels. So with Rex, you never know what's gonna happen, right? He's one of those people that's like a wild card. Wild card. But I will say that I saw, um, you know, Lady Law get up there. I'm gonna have to go back and rewatch the whole thing because, like I said, I fell asleep last night and I didn't wake up till like 10 minutes ago, 15 minutes ago, if that. And I usually wake up a little bit earlier so I can catch lemons, but I didn't. So I didn't get to catch it all. And it was going down over at YTC. So YTC, I did hit your like button and I was in the clouds, but I was half out of it because I'm half sick. I'm sorry if I didn't share right away because I just woke up. Um, but it was going down over there, y'all. It was going down. Um, so the new thing is, they're going to be talking about pretty much the breakdown of what they're going to be talking about, y'all, by what I see. The Just Krista storyline is still a thing right now with Lemon. We'll see if the Buddy Lee thing tomorrow, because it's Friday, his Tuesday and Friday. I found fuck shit Friday that he sorry about that, y'all. If he talks about it and whatnot, and then we'll figure out what's going on from there. But I do know that the Lolo situation with Ness is fixing to be a thing. So that's gonna ramp back up for a minute because the text messages was exposed. Some people gonna be saying, Lolo, what the heck were you thinking? Others are gonna be saying, like, Ness, this girl's crazy, so you're gonna have like 5 different opinions on this matter. In my opinion, I do understand missing the friendship, but on the other hand, if somebody curses you out like that, and Lolo, this is right here an example of why you be careful who you think are your friends and who you talk to behind the scenes, and speak as if you're speaking what you would say in public. This is what we talk about when we talk about people being in the DMs and being careful what you say because it's going to get put out eventually. I'm always careful. I always speak as if anything that I say is public knowledge. And anything I say behind the scenes, I can say in front of the scenes. Right? Now, I will say this, like if this is a situation and I had been friends with the person for over 10, 5 years, whatever, yeah, I would miss the friendship a little bit. Right? But I wouldn't be out here telling certain folk. Now, I'm serious. Be careful who you talk to behind these scenes. Not everybody's got your best interest at heart. And you knew for a fact Exposed TV was Nessa's friend, not yours. You knew that. Like, even if they claim they non-partial, you know where her loyalty lied a little bit. Right? You knew. Can't claim you didn't. So, on this good Thursday, was there anything else, y'all, that I missed? I got to go get a piece of tissue right quick and blow my nose. My nose is running like crazy, y'all. Maybe put down a chat if anything I missed, because I know I missed some stuff. I'm trying to get sick, and so I did stay up a little later than I should have. Listen, I couldn't go to sleep. I don't know if y'all have ever had that issue, and I had to force myself to eat yesterday. Like, I didn't really feel. I don't know if y'all do that. Like, when you get sick, do you feel like sometimes you just don't feel like eating? Because that's the way I felt yesterday. I was like, I don't even feel like messing with nothing. I think it's this weather change that's making everybody feel like they sick right now. And we got a little colder down here in Mississippi than we used to getting. Because y'all know it's usually hot in Mississippi. Well, we usually don't start getting cold until somewhere in November, right? We don't even have fall most of the time. This year we did. I was actually surprised. I was like, oh my God, look at us having fall. Look at us having cold temperatures already. Let's see here. So that's all I saw yesterday. I did see when we was over at the hood tables, right? Big Man TV and me Demetra. I thought Demetra was gonna read him for filth last night, but no, Miss Demetra went live and she was covering the Leilani Simon case. She was covering the Leilani Simon case. I thought she was for some read Big Man Fields. Now, Big Man did do his little thing. Thank you for becoming a member, Happy Life. And then Happy Life and Big Man, we're going to have us a trial date for y'all, too. Yeah, we're going to have y'all a trial date. Thank you for becoming a new member, Happy Life. We're going to have a trial date set and see what had happened. Y'all two kill me. I know that it's not fully up and stuck between y'all two because I know both of y'all. Y'all got neither one of y'all are like vicious like that. In my opinion, I think y'all two like picking at each other. I do. I think y'all two like picking at each other. Y'all like two brothers that just love to pick at each other, and it's like the older brother and the younger brother, and y'all over there doing the little fight thing with your hands, and then walk away. Mom, I don't like him. But that would be a good show, though. We got to set it up like court TV. I'm sorry, Happy Life. See, here's the thing. I would have been your representative, but see what had happened was before you came along, before you came in the sector, like way before you came in the sector, I was Big Man TV's YouTube lawyer, right? And so that was before you came, so I didn't get an opportunity. So now the hood table's gonna be your representative, and we got to pick out a judge. Now Jay Dunn said she's willing to judge, and I think she could keep it impartial. I really do. Think she could keep it impartial. But I mean, she gonna call it how she sees it. So you may not like it. Oh, I know y'all picking at each other. I seen it. I think y'all are hilarious. I think y'all should start a show together, in my opinion. Because sometimes, like, the way y'all bounce off each other is a good thing. You know what I'm saying? Now you know Lolo's gonna try to give in to both of y'all. She's too sweet to be to be like the judge and jury. She gonna give y'all a assignment of hugging it out. That's gonna be her assignment, is hugging it out. That's gonna be her true assignment, is y'all hugging it out. But yeah, I mean, I'm gonna say this. I don't know what's gonna happen in over the day's time today, but I do believe this situation is gonna ramp up. I do know that Brooke and Uppity was having some back and forth this morning. Passes, it was crazy over that Pastor Jay Wilson's the other day. You know, it was, I was trying to keep up. There was so much yesterday that there's no way, with me being sick, I could have kept up. There's no way. I was trying. Now I did make the one of the posters for Lemon's thing the other day. Um, you know, I was just playing around with graphics. I like playing around with graphics. I've figured out that I really like making posters and thumbnails and things and such. I find it to be relaxing and fun. I like making new things for people. Um, because to me it's just, I understand why Miss Coffee loves it. I do understand that now. Like, it's just like putting things together and seeing where they go and what colors look better, what schemes look better. You know what I'm saying? What graphics going to look better here, there, and the next thing. Speaking of which, I'm going to try. The reason I ain't made one for VS yet, I'm going to tell y'all why. Is because I know VS, and she is like, to me, she has like the most perfect graphics already. Right? And I'm scared I'm going to mess up and make something ugly. Like, I know her high standards, y'all. You know what I'm saying? But I'm still going to do it whether she likes it or not. She ain't going to know about it. Shh, don't tell nobody. Y'all didn't hear that from me. Also, if you, you know, we got some people that are going through some things in the sector right now. Prayers for Lady Nika. Prayers for VS Icon that she feels better. I know that she's not been around because she's been handling not only, you know, for herself, but also she's been handling her stuff. But we are going to talk about true crime today. I do have um, some things pulled up. One of them, Jay Dizzle told me about. I got over here. Let's see. Which one am I going to start with? Okay. The story that we are going to do updates. Hey, the People's Champ, Jimmy Newman from the UK. Good morning. We're talking about true crime this morning and a little bit about the sector that I'm from. I'm going to present screen. First, I got to make sure I put my slider. For this is for copyright, you know, disclaimer. Under Section 107 of the Copyright Act of 1976, allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is permitted by copyright statute that might otherwise infringe. Because we ain't infringing on nobody's copyright. I'm not going to ever try to steal anybody else's content. I will always give, you know, the proper, what is that word I'm looking for? Y'all, I'm sick. I'm so sorry. My brain's not there today. I'm always going to give somebody else their props. Hey, Creole, beautiful. So we're going to screen share right now a news article that just happened. I even have the lounge and what happened pulled up. So the first thing, okay, we're going to share is this right here from Law and Crime. This is the exact article that Jay Dunn sent me yesterday. Okay, mom left toddler in an illegally parked car to go drinking at a nightclub. Child later discovered after car towed. Now I will say, I'm gonna say this. I have another picture of her. They did her dirty in this mugshot. They did her real dirty, y'all. Because I'm gonna explain to you why. All right, look right up here. You can see her wig glue where they made her take her wig off and didn't let her wash her face, right? And I just want to know right here on her throat. I don't know if y'all can see that, but there's something like right there. Her lips look like they're dry as crap. Like maybe they kept her in that holding cell so long because I seen a picture of her. She's actually a really pretty girl, but this mugshot don't do her no justice. I mean, she's still like not butt ugly or not, but because of all the stuff from the wig glue and stuff, it makes her, look like she ain't taking care of herself, and that's furthest from the truth. Her lips look ashy, look like she ain't had no stuff on it or nothing. But I think it's because they left her in that holding cell too long. Because when you see the picture of her, actually, she's really pretty, But girl, no matter if you pretty or not, you should not have been doing all what you was doing, leaving that baby in that car while you was going to shake your tail feather. A 29-year-old mother in Texas has been arrested after she allegedly left a 3-year-old son alone in the car that was parked illegally and eventually towed while she went into the club to drink. Brady Rochelle Brown was taken into custody on Monday and charged with one count of endangering a child. Court records are viewed by Law and Crime. According to a criminal complaint filed in Harris County District Court, officers with the Houston Police Department at 12:25 a.m. on Monday responded to a call regarding an illegally parked car in the 2400 block of Wheeler Street. A local tow truck driver had towed Brown's illegal parked car and later discovered a 3-year-old child sleeping in the back seat. The Harris County District Attorney's Office explained that in this case, the tow truck driver towed Brown's Acura down the block from where it was illegally parked before securing it. Houston's Fox affiliate KRIV reported this is reportedly a common practice for tow truck drivers because it reduces the number of confrontations with vehicle owners. As a tow truck driver attempted to secure the vehicle, the driver reportedly realized that there was a sleeping child in the back seat. Court documents state that Brown left the toddler in the car asleep for at least 28 minutes while she went to the club. The criminal complaint further states that she left her child in imminent danger of physical and mental impairment by leaving him unattended in an illegally parked car at night while going drinking at the nightclub, during which the car was towed away with the child inside. Records show that Brown had previously been charged with multiple crimes, including driving while intoxicated and interfering with the duties of a public servant. She was convicted. She was convicted on the DUI charge and did not have a valid driver's license at the time of her arrest. KRIV reported that the toddler was evaluated by medical personnel and determined to be in good health. He has since been placed in the custody of a family member. Brown was booked into the Harris County Jail and released after posting bond. Her bond was $7,500, records show. So that would mean, I don't know if she paid the full $7,500. If that was her bond, then she only had to pay, I think it's 10% of that or 25% of that to get out. Now she may have had to pay the whole $7,500, but I don't think so. I think it's like 75 to 175 or something like that. So she didn't have to pay that whole thing. Most of the time, most bonds, a lot of people don't know this. It's education purposes. When they tell you it's a half or a quarter of a million bond, right? You actually, a lot of places, this happened in Texas, Creole. Yeah, okay. Good morning, Miss LaKendra, my Creole butterfly, my sister from another mister. So basically, bonds are, you only have to pay a lot of times 10% unless it states otherwise. Or, depending on the state, most of the time it's 10% of what you see, right? So if they say it's $1 million bond, then they technically have to pay like $250,000 or $100,000, right, on that bond to get out. So yeah, a lot of people don't know that about bonds. They think they have to pay the entirety of the bond. Not in all cases, unless it states otherwise. Most bonds are 10%. Okay, now from there, right, I'm going to show you, because they have some real pictures on this one. Because I'm going to show y'all how dirty they did her in this mugshot, y'all. She should have never been at the club, leaving her baby in the car. She should have stayed her butt home if she couldn't find no babysitter. That's her fault. You know what I'm saying? And she's already lost her license for drinking, so it's showing she has a problem. Glad the baby's with family now. But I just got to say this. I got to show y'all how they did her dirty on this. Because that is, I mean, look, you can see the wig glue right there. You can see it. They made her take it off but didn't wash the face. I'm just saying. And what is this on the neck? I don't understand. Maybe she got sick or something. But she's actually a really pretty girl. And it's a shame. Also, this is the nightclub that she was at. It was around 12:30 a.m. on a Monday. She was at this club right here. This is the club. I even have the Instagram to the club pulled up. I'll show y'all. She has been accused of leaving her son in imminent danger. In February, Brown, whose license is currently suspended, was arrested for driving while intoxicated and pled guilty to a Class B misdemeanor, receiving 3 days in county jail, according to Fox 26. So she's also got a DUI on her record, and now she has this imminent danger charge with her child, right? Then there was over the summer, another Texas mother, Destiny Morales, was taken into custody on charges of child abandonment, with intent to return. She was allegedly to have gone into Sam's Club in Harris County to pick up pizza while leaving her children unattended for 40 minutes. The temperatures were in the mid-90s, and witnesses called police to inform them that the children were inside the car. Morales told Fox 26 Houston that she would never harm her children and felt like what was reported was the opposite of what happened, but also admitted that she did mess up and felt remorse. That's another picture of Miss Brown. That's another picture of Miss Brown, the lady that left the 3-year-old in the car. I think this is another picture of her too. Yeah, in February, Brown's. Yeah, that's Brown again. Morales told authorities she had only in the store for 30 minutes, but during the investigation, police said that the time was closer to 46 minutes. The young mother said the AC was on and told them her children were not locked inside the vehicle. Fox 5 reported when police arrived, they discovered the air conditioner was on in the vehicle, but said the vents were blowing out warm air rather than cool air on the scorching day. After Morales ordered the pizza and walked outside, she said her children were already outside the car. She saw some of the store employees looking after her children, and she was arrested shortly after. Now, when we look at those situations, they're different, right? One mom was going into the thing, to party, while the other mom was going to get a pizza for her children, right? But the one mom, it was during, hey, Hazel, boo. One mother was going in to get the pizza, right? So the one mom was going in to get the pizza. She thought she had the air on. The air was, hot. So she thought she had the air on. She was going in just to pick up the pizza and come back out. Now the other mom left her 3-year-old who was sleeping in the car so she could go shake a tail feather and get drunk at the bar. Right? In your opinion, are they the same in your eyes, or are they different because the circumstance is different? Right? In my opinion, don't leave your kids on a car on a hot day whatsoever. Like, take your kids with you. But is one worse the other? Because one left their child at 12:30 in the morning while they were asleep in the car to go get drunk and shake a tail feather, while the other one was just picking up a pizza. But can I ask this question? I've never seen well, the lady who left hers in the car, let's see. The 3-year-old was the Brown case, right? The Morales, let's see, did I pull up? Because I could think I did pull up the Morales case. Let me pull up here and see if they even said the Destiny Morales. Let's see. I'm looking up her case right now, so if we could see the ages of the children in her case, because I don't think it's stated in that article. The ages of those children. Okay. She left the kids in there for 46 minutes. It says that she said she was gone for 30. Um, let's see. Well, are they going to say the ages of the children, y'all? I do not see that so far. I'm looking. I could have I saw a thing that said how I think she had 3 children where the other lady only had one. I'm trying to look at the kids' ages right now. Oh, she left 4 children. It wasn't just 3. I thought it was. They said 4 in the other one. She was charged though with that case. Let's see. Well, that thing just totally. Okay, let's see. I'm looking up trying to find the. Okay, here we go. A Houston woman was arrested after she left 4 children inside a hot car for 46 minutes, according to Precinct 4 Constable Mark Herman. The 3-year-old twins and 2 other children were spotted by witnesses inside the car locked. Herman said the kids were yelling, sweating, and appearing flushed. It happened on August the 1st at Sam's Club on East Ritchie Road. Destiny Morales, 29, left the kids in the car while she went inside to pick up a pizza. According to Herman, the vehicle's air conditioner was running, but Herman said that it was blowed warm air and it was a 95 degrees outside at the time. See, now that can lead to a lot more health complications. But that's why I guess that, 46 minutes. 46 minutes. She tried to claim it was 30 minutes that she only went in there to grab it, but it was 46, not 426, 4D6. That's a long time. I ain't never heard it taking that long to go get a pizza. How much was the line over there? How much was the line? Hey, Miss Jean. Good morning on Wild with Messi. But yeah, so it's 2 different cases basically on that one. Now, this is what I'm showing y'all right here. The reason I show this is to show you what that nightclub looks like. I gotta scroll down here. This is what it looks like, right? I was gonna show y'all some of the videos. It's just a little hookah bar where they do. Okay, that was not gonna show well. Let's see about this one. Like, this is from outside the club, what it looks like outside the club. I was just doing this to show y'all. That's what it looked like inside the club. So it's not like a huge, huge club, but it's big enough. It's one of those little where they do different things. They do like karaoke night and all this other stuff. I would play the music, but I don't know if it's copyright or not. But so they do like events and stuff like that, and that may have been her spot. But that's to show that this is their little area. I was wondering in some of these. I tried to watch all these videos yesterday. Y'all see if we could see her in the video, but there's it goes so fast, like a lot of the videos do. Like they have the ladies' night. This is what right here. If you look, their karaoke night, and you can see that the cars are all parked there. So I'm guessing that her car was illegally parked somewhere over in this area or somewhere along the street when it wasn't supposed to be, right? And that's what I'm guessing, that her car was illegally parked somewhere that it wasn't supposed to be, right? And she was drinking. Now the one, the Brianna, not Brianna. Why did I say Brianna? Her name was Brandy Brown. Brandy Brown. Make sure I'm getting that name 100% correct. Brandy Rochelle Brown. That was her name. Now she had a 3-year-old in the car, and she went inside the club and was drinking. And she's out on bond right now. Oh yeah, we're gonna talk about Leilani Simon's trifling butt in a minute, Miss Demon. So good morning. Also, I was just bringing up a small case that we saw yesterday about 2 different situations with one mom who was actually trying to go into the store, but she had the air on. Didn't, I guess, she had to know that air didn't work if it was just blowing hot air. And she left 4 kids in the car, but she was picking up a pizza, you know. But at the same time, was she really picking up a pizza? You could have that thing. But that's yeah, so she's out on bond right now. She's already got a DUI um in Harris County, and all that. I'm gonna keep an eye on that to see if she gets any charges or whatnot. She's actually a really pretty young lady, but they did her wrong in her mugshot, y'all. I'm just saying. So right now I'm actually going to bring up the information for, Leilani. Why is my caps lock keep coming off? Okay. We're going to pull up some new stuff on Leilani and go over um, what's going on so far, because the closing statements begin today, y'all. They said closing statements set to begin Thursday, and so we will be shortly knowing some things. Probably however long it takes them to, I would say sometime this next week, about what's going on. So the closing statements are going to take part today. We're going to share this tab instead. So the closing statements will be going on today for the Leilani Simon case. So if y'all have been keeping up with the Leilani Simon case, it's the one where her 3-year-old, not 3-year-old, he was a year and he was like 20 something months. He was almost 2 years old, not quite. He was unalived, and they found him in the landfill. His body was dismembered and blah blah blah. They showed where she put him in the trash place. She lied and said that she went to go get some Oragel that morning, and we come to find out she was going to get drugs that morning. So I'm going to show this article over here. Let me go ahead and knock off some of this. We also have pulled up over here. I have pulled up. There was also this case that I was looking at that I didn't know if y'all might find interesting. Oh yeah, we also have to talk about the lady who put her husband in the thing. But there was this case of this lady who literally tried to eat her mom, like had her in pots and stuff. I didn't know if y'all might be interested in that one. That one's going to be coming up soon. There was a lady who literally was aspiring to be an actress and had her mama in a pot, y'all. Had her mama in a pot. Like, I'm like, what? All right, let me get this update up here for Leilani's trial. This is day number 9. Okay. Savannah, Georgia. The state and defense rested their cases in the Leilani Simon murder trial on Wednesday. In total, the jury heard from 33 witnesses, ranging from FBI officials and local police detectives to Simon's brother and her then boyfriend. The Chatham County mother, accused of killing her 20-month-old son Quentin and throwing his body in a dumpster, declined to testify. Complete on Thursday, day 9 of the trial, the jury is expected to be brought back in at 10 a.m. for closing arguments. WSVA will stream the proceedings live on this page. The court has decided it can be streamed in real time rather than a 30-minute delay. So they are doing closing arguments today for the Leilani Simon case. So we will be getting a verdict on that one. We will be. So we know that's the thing. That's going to be coming up today. So we will be getting a verdict on what's going on with Leilani. And I'm also fixing to type in the other case that we've been following y'all about the suitcase lady. Can I even type today, y'all? Okay. Don't tell me she was on. Oh, she went on the stand? Oh, we got to watch this, y'all. Hold on. I got to make sure this ad plays. And if it's a switch over, we're going to share this. We got to watch this, y'all. The suitcase lady, I think, went on the stand. Oh, cha. You know, the suitcase lady. But yeah, we're going to talk about that. I'm going to drop the link here in a little bit. We're going to catch up on some of these cases that we've been watching and whatnot. And I am going to bring up the Kentucky lady who illed her mother and cooked her. She literally illed her mother, y'all, and cooked her in a pot, like some stuff from Jeffrey Dahmer, y'all, but it's a woman. All right, we're gonna watch this one right here, and we will be finding out today if in case you know, with the Leilani, if I'm still on at 10 when she pops up, I will be streaming that. We're gonna go ahead and go over here, and we're gonna put on the Sarah Boone thing. We're just gonna watch some stuff about this case, because I know that a lot of people have been following the lady in the thank you, new member, Jay Dunn. Thank you, Jay Dizzle. But we are going to be getting, you know, closing statements today. I don't know when we're going to be getting, you know, how long it's going to take the jury to deliberate. If they come back today, which is very rare if they come back the same day. But if they come back today with it, I will be doing a broadcast, even if it's short, breaking news, you know, because I know that a lot of people have been following the Leilani case. And so if she does, I will be coming back today for us to come talk about it. You know, it may be later in the day, but I ain't going to let that one slip us. And here's a update on the, let me unmute it. The, trial that's for the suitcase lady.
Who evaluated Sarah Boone, who's accused of zipping up her boyfriend in a suitcase, killing him, says she has battered woman syndrome.
And Fox 35's Stephanie Buffamonte was inside the courtroom again today when that doctor took the stand.
Of the 6 jurors, 5 are women, 1 is a man. I saw one of those female jurors inside the courtroom taking a lot of notes and nodding her head as experts were talking about the battered spouse syndrome.
Is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior.
The psychologist who evaluated accused murderer Sarah Boone backs what the defense has been saying. Dr. Julie Harper says she believes Boone is a battered spouse.
Their fear is based on the pattern of behavior between them and their partner.
Boone is accused of zipping her boyfriend George Torres up in a suitcase and leaving him to die in it. On the stand on Tuesday, Boone said the two were playing a game of hide and seek until Torres changed his tune. She says they went from laughing to arguing and claims he threatened her life.
Can you tell the jury what he was saying?
That he was going to end me.
So she left him inside the suitcase.
he probably would have made me unrecognizable, or I would have lost my life.
Dr. Harper diagnosed Boone with PTSD and said she had trauma from intimate partner violence. When the state got a chance to cross-examine Dr. Harper, they brought up that battered spouse isn't a medical diagnosis and questioned the doctor herself regarding what she asked Boone about that night in February 2020.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying. She said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important.
Okay. Then explain. Why wouldn't you ask that question?
Because as a person who is traumatized is describing their experience as a trained clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation.
Court resumes tomorrow morning at 9. The defense is expected to rest their case in the morning. Reporting in Orlando, Stephanie Buffmonte, Fox 35 News.
So on the Sarah Boone case, we also have, it's going to be coming to an end soon too, for the jury to deliberate on whether they think that she's guilty or not. So we have the two cases going right now. I am going to read this article right quick. Give me just a moment. Okay, so this is what we know so far on the Sarah Boone case. I'm going to read this article. Orlando, Florida. A Florida woman on trial for murder after her boyfriend died in a zipped-up suitcase during an apparent drunken game of hide-and-seek took the stand on Tuesday in her own defense. Sarah Boone, 47, faces a charge of second-degree murder, accused of leaving her boyfriend George Torres. Why did I call him Jorge? Maybe because that's the way you say it another way. But 42 to die of asphyxiation in a zipped-up suitcase in the 2020 during what she called a drunken game of hide-and-seek. Boone said the suitcase had been moved downstairs about a week prior to Torres' death because they were going to do some spring cleaning and donate items to Goodwill in the luggage. Boone testified that Torres got in the suitcase himself and was trying to get himself flat so she couldn't tell he was there. He was 5 foot 3 inches tall, roughly, and he weighed 100 pounds. I just kind of zipped him up. We thought it was funny. We were joking that he was small enough to fit inside a suitcase. She said she zipped the suitcase, and at some point, he just thought it was funny. And from there, I moved it around a couple of times on the wheels, and at that point, it was still funny. We were joking and laughing about it. She said she moved the suitcase around, and it ended up with the zipper side down. That's when I decided to videotape to see the jest in it, for him to understand that right now I feel safe and I can speak to you in a manner in which I normally can. I think she meant can't. She said, admitting that she was intoxicated. Could you tell the jury what you were feeling, what your feelings were? Explain to the jury. You said it before he was in that confined space. Boone's attorney said, I want you to know that a majority of the time I'm always afraid and always scared. Boone replied, I just wanted him to understand that was the whole point of the video. After you hit him with the bat, was he not trying to get out anymore? Her attorney asked. Yes. Do you believe he could breathe? Yes. Do you believe he could die? No. Did you try to ill him? No, never. Did you want to ill him? No, I did not. I don't know. Did you walk upstairs? I did, yes. Why didn't you let him out before you went upstairs? Were you afraid? Terrified is more the word. She later said that she believed Torres was going to ill her and he was going to effing end me, she said. End you? Her attorney asked. Yes. The state continued its case earlier Tuesday, a day after jurors were shown video of Boone being interrogated by authorities. He's begging for you to let him out. You're laughing at the beginning, and then you're like, No, a detective said in the video. It was not intentional, Boone replied. I will put my hand on the Bible. It was not intentional. So we're going to watch this video right quick. After obviously the ads, this is a case that's going on right now. So we're going to watch this.
The Orange County woman is expected to take the stand in her own defense to testify about the night her boyfriend died in a zipped up suitcase. News 6's Angie Quezada is there live at the Orange County Courthouse. And Angie, this comes one day after jurors heard and some saw some damaging evidence.
Yeah, Sarah Boone is expected to take the stand before noon today after the prosecution rests its case. And this is after a powerful day in court yesterday where jurors got to hear from Boone herself in hours of interrogation videos.
He's begging for you to let him out. You're laughing in the beginning, and then in the end, it sounds kind of like no, it's not malicious.
Sarah Boone, the Orange County woman accused of killing her boyfriend by leaving him in a zipped up suitcase in 2020, insists what happened was not intentional. The jurors watching hours of video yesterday of her being questioned by detectives.
It was not intentional. I will put my hand on the Bible. It was not intentional.
Boone says she and George Torres were playing a drunken game of hide and seek at the time.
So you all think that it's like, oh good, I got him in there, now I'm going to go sleep? Is that what you guys are trying to assume? Or trying to the video is very portraying of the opposite of what you told us.
The state medical examiner showed jurors diagrams and photos of injuries she says were consistent of being hit with a baseball bat and the suitcase being thrown down a flight of stairs. Both the state is accusing Boone of doing. Now, during the interrogation yesterday, Boone was forced to watch a video that she allegedly recorded with her cell phone where Torres is begging for help. She responds with vulgar language and then walks away. Of course, I'll have more on that report in the next half hour. As for today, court is set to resume at 9 o'clock, again, with Boone expecting to take the stand before noon. And of course, we're going to be live streaming that over on clickorlando.com.
Okay, so, we're sitting here looking at that. We saw a little bit of the interrogation. It says, earlier in the day, the state called Dr. Sarah Zadowich, a forensic pathologist for Orange County, to stand. Zadowich performed the autopsy for Torres and said she had only seen a handful of cases like this. Keep in mind that while he's in the suitcase, every time he's exhaling, he's pushing out carbon dioxide. So whatever oxygen is there is most likely diminished because it is in an enclosed space. It doesn't have to be no oxygen, but it's decreased from what we would have in a normal room. Orange County Circuit Judge Michael S. Kranick last week swore in the jury of 6 with 8 alternates while opening statements were presented and testimony began. On Friday in Boone's murder trial, the jury heard opening statements Friday morning with the state claiming that Boone murdered her boyfriend while the defense said it was self-defense. The prosecution's opening statements were delivered by Assistant State Attorney William J., who said she did this with the malicious intent to punish him, and then she went to sleep and left him to take his final breaths on this earth alone. He also spoke about Boone's 911 call the next day. What you will not hear are tears. What you will not hear is sorrow. Prosecutors said that Boone showed no regard for Torres' life, but her attorneys claim that she was the victim of a battered spouse syndrome and locked Torres in the suitcase because of prior abuse. The state said Boone never mentioned self-defense when it first questioned by authorities. Following Tuesday's hearing, the jury is set to return on Wednesday at 9 a.m. This is basically the one we watched the other day with Demas O about where he was begging for his life.
At T-Mobile, we offer 40% off family line.
Yeah.
Happening right now, state prosecutors are making their case against a woman accused of killing her boyfriend years ago. Sarah Boone is accused of leaving her boyfriend, George Torres, to die in a zipped-up suitcase in 2020. Prosecutors called Dr. Sarah Zudovich, a forensic pathologist for Orange County, to testify today. She did the autopsy for Torres and says she has only seen a handful of cases like this.
Keep in mind that while he's in there, every time he's exhaling, he's pushing out carbon dioxide. Okay, so again, whatever oxygen is there is most likely diminished because it is an enclosed space. It doesn't have to be no oxygen, but it's decreased from what we would have in a normal room. But every time that he's exhaling, there's more carbon dioxide that's in that space as well. So that displaces any oxygen that might be there too.
Boone is being charged with second-degree murder. If found guilty, she could face up to 30 years in prison. We'll have another update from court on News 6 at 4.
At T-Mobile, we offer 40% off family lines for military and
So we know that she is facing 30 years. It's okay, Ray. You had a phone call. It's cool. We know that she's facing 30 years, right? I'm going to see right quick if there, let's see, updates. So that we can make sure we give everybody the updates on what's happening with this case. Now, I will say that Miss Demetra Lit all day has been doing the Leilani Simon case. It says, we're going to read this one. Orlando suitcase, murder trial, daily updates. Sarah Boone stands for trial for allegedly murdering her boyfriend. Okay. Let's see. Now, the defense calls on more witnesses on Wednesday after Boone set the stage with her Tuesday testimony, saying that she left Torres Jr. trapped in the suitcase because she was afraid of what he'd do to her if he got out. The defense began to call on more witnesses Wednesday morning. 2 of those witnesses were Orange County deputies who said they responded to domestic calls at the couple's Winter Park home in 2019. A deputy said they observed swelling and bruising in Boone's right eye, as well as red markings and some abrasions around Torres Jr.'s neck. The trial resumed at 1 p.m. with the defense calling on even more witnesses. Boone's attorney called Dr. Michael Brannon from South Florida to stand Wednesday morning. The forensic pathologist explained victims in abusive relationships can have an altered sense of danger. Whether it is the lid of a garbage can hitting you on the nose or whether it's someone being abusive towards you, these situations change your perception of danger, Dr. Brannon said. So you no longer see the object or the person the same way. You have a foreboding sense of danger can occur. Dr. Brannon did not evaluate Boone, but psychologist Dr. Julie Harper did during 9 meetings. Dr. Harper told the jury Boone does not have a personality disorder. Did you determine that she did suffer from trauma as a result of intimate partner violence? Boone's attorney James Owen asked Dr. Harper. That was my conclusion. She said, yes, that's my opinion. During Boone's testimony on Tuesday, she showed jurors the scar on her leg where she said George Torres Jr. stabbed her with a steak knife while she was making him dinner. Dr. Harper told the jury she diagnosed Boone with PTSD. In my opinion, at the time of the offense, she had depression and she had an alcohol use disorder. Dr. Harper said on Boone's mental state in February 2020. The state cross-examined Dr. Harper about conversations she had with Boone about interactions with Torres Jr. while he was in the zipped-up suitcase and her decision to not let him out after he told her he couldn't breathe. What made her mad was not that he was saying he couldn't breathe, Dr. Harper said. He was saying that was making her mad. So you didn't elaborate what some was that made her mad? The prosecutor asked in the follow-up question. Dr. Harper replied, right, before elaborating her meeting with Boone were not part of an interrogation. The defense has yet to rest its case. The jury went home before 5 p.m. and will return to the courtroom Thursday morning at 5 day 5 of the trial. So we do know with this, they've showed quite a bit of evidence where, in some instances they say that she was a battered woman. In other instances, they're stating that, she could have left. Right? That's what they're stating. So that's a huge thing right there with that case. So we're still going to keep an eye out because they did say in one of the updates that they think the defense is going to rest soon. And they said that 2 hours ago. So it's actually, let's see. Let's see if this is the one from today. I'm trying to make sure I get y'all the correct information. Okay, let's see. Let me go to YouTube. All right, here we go. We're going to start watching and see what happens on this one.
that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply. In her opinion, that was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them, based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes. That's fundamentally, substantially, materially different from what what she's testified as it relates to post-traumatic stress as it applies in this case?
In the proffer?
Excuse me?
In the proffer? She's not rendering an, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back. When it was first going on, when a question was asked, and I believe she rendered an opinion, and I, again, like that to be reread back. What the initial question was, what the response was, because it didn't. I know I objected. I can't even remember it now. But I know I objected because I knew it was inconsistent.
You asked to approach, and then you explained that the question was it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So I can
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind. Yes, ma'am.
Hi, Mr. J. Question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial.
Someone singing. Y'all for dance for Tough Gun. Y'all for dance for Series Radio, right? What for dance?
Oh, I was waiting on you. Please, go ahead. Sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end some general, if you have any new opinions or anything new that differs from what you've said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about,
specifically asked you, Mr. Owens, to point out for me excuse me. I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified.
The ones that I expressed, and that just the understanding that we had that she, in the pages that I have talked about previously here today, in the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J?
Okay.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial, although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry?
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions. And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren.
Yes, sir.
Good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion is relating to a central issue in this case.
Correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Mr. J, anything else?
I'm just making sure he doesn't want to inquire.
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
You want to be a software engineer, right? Go to eldacademy.com. Use our step-by-step code.
In these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom.
Yes, sir.
And we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who was on trial for murder in the second degree?
I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge.
Yes, sir.
We're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial.
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
Dr. Warner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have, I'm leaning towards the adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that. Yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can.
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
Does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against us in court this morning.
They're still under defense subpoena.
I asked Mr. Henderson if you guys were calling Capsule again, and he said no.
And we're not in our defense, our direct defense. Is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed their presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But
It doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and then comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No, sir.
Anything else, state?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
Check out this free extension that recovers ocean-bound plastic when you search the web or open a new tab. I downloaded it.
So on this one so far, do y'all think they're trying to throw out the case? Like, that's what it seems like to me, like they're trying to, do something. We are going to do an update on the Lillian Simon. I'm keeping an eye on it because the jury is deliberating right now. I'm not exactly sure we're going to get that in, but we are going to update on the Lillian Simon case. We're going to watch this right quick to see if they said they wasn't throwing out the doctor, but let's see what they say with the jury.
State, you recognize our jury.
Yes, Your Honor.
Spence, do you recognize our jury? I thank y'all. You can be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
Yeah, so they're approaching if it's gonna talk about the situation. Ooh, we chat. The reason they mute out when they approach is because it's between the judge and the council members, and they don't like the jury to hear what they're talking about, pretty much, because it can affect or sway the jury and stuff like that. if they throw out that witness, though, if they throw her out, which I'm glad they did not, because if they decided to do that, there goes her entire defense. Or that's a huge one right there, because she does need to be evaluated
Objections
again.
overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Yes.
That doctor, look at her face, y'all. She looks so like, oh my God. Look, y'all. She's like, oh my God, can we get this over with? Chad. I'm being her brain right now, right? I'm saying what she's thinking. She's like, oh my God, this is ridiculous. So her brain's coming out right now. Oh my God. Can we just get on with this so I can get off the stand? But I think I do agree, Miss Jean, that she needs to be evaluated again, and they need to have multiple evaluations, right? From multiple people. That way that they can have like differences of opinions. Some may agree that she's battered, some may not, right? But the problem now is everybody's seen the case, so who's going to be impartial? That lady looked like, oh my God. Look. Let's see how long this pause is going to take, y'all. But I am looking up the Lillian Simon case as we're doing this, because I am going to give update on that as it comes in. This is a long pause, y'all. Sometimes they be having, it could be more than PTSD. It could be, her whole defense depends on whether they believe that she had battered spouse syndrome or not. So if a bunch of doctors are saying they don't believe she has that, or that she didn't act in that defense, her entire defense goes out the window. So that's another reason why they're being very picky and particular about this witness specifically, and the witnesses that are doctors, because her entire defense is based on this right here, right? So we're going to have to see how this plans out, because if they throw out, which they didn't throw out her testimony, obviously we saw that, but if they did, then that could both hinder both prosecution and defense depending on which way she's leaning, right? If she's leaning more towards that's not a good defense, then that would actually hurt the defense. I mean, if the defense that she's using is no good, that would hurt the defense's case. If she's leaning towards, but they do need to reevaluate and have multiple evaluations done, and there's a reason why. Because one doctor may believe one thing in their expert opinion, and another doctor may believe it another way, and I think that would leave it more impartial. But yeah, for somebody to be laughing while somebody's crying and think, That is a whole thing. Like, if I know y'all saw the video when I shared it of her doing that. But y'all, I gotta be the inside brain for the lady right now. Oh my God, look how long they taking. Like, I didn't. If I had known they was gonna do this, I wouldn't even involve myself in this case. Sweet baby Jesus, why am I sitting here on this stand for so long? I'm hungry. Y'all know I could have some chicken today. I was thinking about that burger from down the street though. For real though. I know this is a Erdertron. It's very serious, but I'm trying to,
Members of the
make it a
jury,
laugh.
I have something I've got to discuss with counsel outside of y'all's presence. Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
Here we go again, y'all.
Y'all can be seated. Thank you. Madam Court Reporter, when you're ready. Yes, ma'am. Just read it from the question, answer, question, objection. Let's just have we can buttress it. Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether this building is suffering from PTSD or ESS, facts of this case, does PTSD or ESS have any relation? Mr. Owens' objection asked and answer. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing when he got into the suitcase. When she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
Judge, it's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time despite his mental illness because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony, Judge.
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims, Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion. See section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and answer, and then I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled. There was a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for mine.
We're going to begin your cross-examination after we're done with the state advises the jury in open court. There are no more questions. Let's go ahead and bring back in our panel.
Where's Henry?
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? You may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Question by Mr. J. All right, irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or ESS, irrespective of that based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and ESS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek. They were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Dr. Warner, good morning. What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial?
Listing your vacation rentals on Booking.com opens the door to more guests, like this bunch. These lovebirds. Or this fine company. For the bookings you've dreamed of, list your vacation rentals on Booking.com.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection, you approach?
Yes.
Boy, they objecting this witness and objecting this witness and everything she say. But basically what they're trying to do right now is what we're seeing is they're trying to show like they had their expert with the defense, right? So now they're trying to show an expert on their side. So basically conflicting experts and what each expert ultimately thinks about this case and whether she was in imminent danger or not, and whether battered spouse actually applies, and whether or not, at the time when this incident happened, was she in the right state of mind to make this decision, like to ultimately take his life? Was she feeling like she had no other way out at that moment? So they're showing conflicting, so the jury can make an informed decision on whether they believe one expert over the other expert. That's what they're trying to do right now, pretty much.
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
Woo, Lord, this is the most objections I've seen in a minute, y'all. But yeah, they're trying to, both go for their side because her testimony can conflict with what the other experts stated. So that's why you hear so many objections. They're trying to make sure the jury, each side is fighting for their side, right? And they're just wanting to show that one expert states she does have battered wife, the other does not believe she does. And this can determine whether or not her defense is plausible. Because if the jury thinks that her defense is not plausible, then it goes out the window. And without that defense, right, if she didn't feel like she was in imminent danger, then she did, murder him without the self-defense, right? So right now they're saying that it's battered wife syndrome. There is no, like, we know she did it, but this right here is going to determine whether she did it out of self-defense or she did it maliciously, right? She did it knowingly, like she was just so that's why we're listening to these expert opinions. It's because these experts have seen the thing. They're using their deduction and reasoning. They interviewed her. Some, the one expert believes she does and did feel like she was in imminent danger. This expert believes that she was not, because they were playing hide and go seek. They were being, getting drunk together. They were having fun, so, this expert believes this. Now, in my opinion, if y'all in the chat, who do you think that she believes she was in imminent danger, or do you believe that she might have been drinking and left him in there and thought it might have been funny? Do you think she intentionally did this or didn't intentionally do this? It's up to y'all, and ultimately the jury at this point. Also on the Lillian Simon case, Leilani, they did the defense, they rested the case, the prosecution did, and they saying that the defense rested also. So basically what we're waiting on now is you know what's going to happen from here on out. So we're just waiting on the update. I'm steadily looking for the update on what's going to happen with this case, because we're going to be getting what happens soon from the Leilani case. Oh yeah, I got something I just looked up. I looked up Henry Bubba, right? Henry Bubba Moss. His father, the grandfather of the missing Georgia toddler, Quentin's grandfather, actually got hit and was fatally struck by pulling by a car when he was trying to change his flat tire. Um, like he passed away in 2022, I believe. So that's crazy. I just looked up because I'm trying to figure out. I was trying to do more research on Henry Bubba, as Jay Dunn states, and the grandfather, which is Henry Moss Sr., uh, was fatally struck after pulling off the side of the road. So that's what local reports are saying. Um, I'm reading some stuff about the Leilani case right now while we're, going through what we're going through. It says that the missing Tyler Quentin Simon's father says mom Leilani blamed him for the disappearance. So like she did try to put that off on the birth father. They said that Leilani told the police that that Bubba had came and got the baby for overnight. They asked, did he have him? When was the last time he was in Savannah? And then the father said he told investigators he had not been in Savannah area since he installed an air conditioner about a month ago in Tybee Island, where Leilani and her mother Billy Joe Howell were spotted downing shots of tequila last week. Moss told Daily Mail he provided the police with his alibi and his whereabouts at the time of his disappearance. He said he told the police she's going to hurt that baby. I said I didn't know what was going on. Heck, I haven't heard from her in 6-7 months. Quentin's father said she didn't tell me until months later that she was pregnant. I didn't have no say in it really. He was happy and always smiling. He really didn't scream a lot. He was a good baby. In February 2021, Moss was served with an arrest warrant in connection with the June 2020 trailer home break-in, for which she blamed him after she was arrested. A police report cited the outlet stated that Simon allegedly stole $50 from a coin jar at the mobile home park. See, I knew it something had to do with Bubba. When asked who the victim, thought was responsible, he pointed out a female later identified as Leilani Simon, who lives next door and was currently standing outside. And Miss Simon added that her child's father, Henry Bubba Moss, came over at approximately 8 a.m. today and convinced her to help him enter the camper. Mrs. Simon stated that since he couldn't fit through the window, she did instead. So that was, Bubba was the one that she said that about. Bubba did call, So yeah, there's a lot. If you actually look up Henry Bubba Moss, there is some stuff about and he did say, Moss stated if she didn't want him,
Objections
she could have
overruled. You may
told me.
proceed.
I would have came and got him. So the dad would have came and got him.
Ma'am, is it fair to say in your evaluation of Sarah Boone on October the 2nd of 2024 that you felt like the text messages that you received from the state attorney
Overruled.
are not relevant to your evaluation of Sarah Boone?
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes.
And we discussed that these were the phone records from Sarah Boone's phone.
Yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it, if you just refer me to the page.
Just a moment.
You got it?
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5, approach.
Lord, they have so much going on with this one, don't they? But yeah, so if you look up Quentin Moss, he said that for the Leilani case that he would have took his child, but he didn't have a choice on whether or not, she did that.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone? Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's talk. First, you said no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct.
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct.
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, we need to object. We need to
Yes, Miss Demon. So I'm actually fixing to stop this, and we're going to come back to this later because it's probably going to go on for a while. I do have an update on the Leilani case. It's not whether she's found, guilty or not guilty, but I want to share something that I just found on the Leilani case, right? Where we were talking about Henry Bubba and whatnot. We're actually just to learn more about him because I looked him up and everything. So I wanna show that right quick and read it, and then I'm gonna drop the link so we can talk about it and whatnot. Okay, because this right here is some stuff that's leading into stuff that I don't know if a lot of people know. Okay, we're going to go from up here. Okay, so we know that Quentin was reported missing from Savannah home in October of 2022. His remains were discovered at a nearby landfill more than a month later. His mother, Lillian Simon, is accused of murdering him and leaving his body in a dumpster. Jury selection began, this was from Wednesday. Okay. On Thursday, prosecutors sought to exclude evidence to show Lillian Simon's mindset before her toddler son was ill. During a motion hearing, the state introduced several pieces of evidence, some of which had been previously ruled irrelevant, as well as a timeline of events the night of Quentin's disappearance. Prosecutors say Lillian got into a fight the night of October 4th, 2022, with her boyfriend and the father of one of her surviving children, Daniel Youngkin. She left the home and later returned. At some point at that night, she was under the influence of marijuana, Percocet, and cocaine. The state argues Simon was upset about Youngkin's feelings towards her, fearing he didn't love her anymore. That led her to making a video in August 2022 where she said goodbye to her family and implied she was going to commit suicide. Simon was seen wiping tears from her eyes while watching the video in court. Prosecutors argued the video, as well as Leilani being kicked out of the home by her mother, so she was in an agitated state in the months before Quentin's death. The defense said Leilani's video was a Hail Mary pass by the state and that is irrelevant. No threats were made during the course of the video. Police were also asked in court where Leilani admitted to taking cocaine. She said, "It's almost like blackout drinking. The light is on, but nobody is home." The state argued that her drug use is paramount to the events surrounding Quentin's disappearance and death. Prosecutors also sought to include evidence surrounding Leilani's partying on Tybee Islands in weeks following Quentin's disappearance. Leilani Simon was desperately unhappy, said Assistant District Attorney Jenny Parker. She also felt so low and desperate she killed Quentin Simon to be loved. Following a brief recess, the state brought in two witnesses they believed also corroborate the evidence presented. Melanie Boeing, 28, testified that she met Leilani after her and then boyfriend Cody Wharton moved into Bowling's neighborhood in 2017. Bowling told attorneys that at the time she saw Leilani as a little sister. Bowling, too, was a teen mom and testified that she knew the struggles Leilani was going through as a teen mom herself. After Leilani broke up with Wharton, the father of Leilani's first child, Bowling testified that Leilani met Henry Bubba Moss, who later introduced her to what Bowling called hard drugs. Moss is the biological father of Quentin Simon. Once Lillian became pregnant with Quentin, Bowling testified that Moss urged Leilani to get an abortion, which Leilani did not want to have. Bowling testified that Leilani told her several times, "Maybe if I didn't have Quentin, I'd still have Bubba." Throughout her testimony, Bowling also detailed several instances where over the phone she heard Leilani verbally and physically abusing Quentin. Meanwhile, Leilani, seated in court with her hair in a ponytail, dressed in a flower print blouse and khaki pants, was shaking her head as if to say no numerous times throughout Bowling's questionings. During cross-examination, defense attorney Martin Hillard questioned Bowling's relationship with Leilani, attempting to prove the pair weren't as close as the testimony would lead one to believe. When asked, Bowling said her conversation with Leilani went from daily to weekly to monthly, then every other month until Quentin disappeared. While being questioned by Hillard, Bowling admitted she never physically met Quentin. The state then brought forward 17-year-old Taylor McCarter. She and her family regularly babysat for Quentin and Leilani's other two children. McCarta testified she witnessed several instances of abuse towards Quentin and that it seemed Leilani favored her other two children over him, even going so far as to say that Leilani didn't love Quentin the same as her oldest child or the child's father. The reason this evidence and testimony was heard was so that Judge Tammy Stokes can decide whether it's admissible once the trial begins. After reviewing the arguments, Judge Tammy Stokes decided that nearly all of the evidence and witness testimony is admissible. Okay, and then we have right here, right as I scroll down, let's see. There is a part about, oh, here we go. Let's share this tab instead. Who is Henry Moss? Quentin Simon's dad reveals Leilani Simon tried to pin toddler's disappearance on him. Missing Georgia toddler Quentin Simon, whose mother Leilani Simon is also a prime suspect, tried to pin the 18-month-old child's disappearance on his biological father, Henry Bubba Moss. It has been nearly 3 weeks since we already know all this, right? Leilani allegedly told the police that her ex-boyfriend snatched the toddler from her Savannah home in the night, prompting the police to track down the long absentee father and confront him. Henry Moss, who is known as Bubba, lives in Gurad, said when the police confronted him, he told them he had not been around Savannah for months. Bubba was mowing his boss's lawn when the police arrived. They asked, did I have him? When was the last time I was in Savannah? He recalled. They told me Leilani said I came and got him overnight. Leilani tried to blame it on me, he told Daily Mail. Bubba told the police he had installed the air conditioner in a nearby Tybee Island, and that's where he saw Leilani and her mother, Billy Joe Howe, doing tequila shots a week after Quentin's disappearance. Bubba swore that he told the police the truth and that he only left his house for work at 7:40 in the morning and presented alibis, and there was CCTV footage from the next door gas station to prove his innocence. Bubba recalled telling the police, she's going to hurt that baby. I said I didn't know what was going on. Hell, I haven't heard from her in 6 months. Quentin is now widely believed to be, we already know he's passed away, and we know his mother's the prime suspect. Bubba then continued to share some backstory on the mother accused of their son's disappearance. Bubba, who has daughters with another woman, said he met Leilani at a swimming hole. She had her own child, Zane, at the time. They began dating when she got pregnant with Quentin. She did not tell him the news initially and kept it a secret. Leilani moved to Alabama to deliver the child in January of 2021, so Bubba's name was not on the birth certificate, and she returned home. He was happy, always smiling, Bubba said of Quentin. He really didn't scream a lot. He was a good baby. Bubba said that the breaking point in their relationship started in February of 2021 when he was served an arrest warrant for breaking into a trailer home back in June of 2020. At the time, Leilani had already been arrested for a crime committed in the mobile home park when she was living with her mother in Waynesboro. However, she blamed Bubba. Liliana allegedly cut her way through a screen window and stole $50 from a coin jar. The victim and owner of the trailer said the suspect was a woman later identified as Leilani Simon, who lives next door and was currently standing outside during the investigation. Leilani initially admitted to the crime and added that Bubba convinced her to help since he couldn't fit through the window. She did instead. It was pled down to criminal trespass. Court records show she was given 12 months probation. She is still on that probation and another probationary period for a 2021 theft in North Carolina. So she's got 2 thefts on her records. Leilani and her mother were evicted from the trailer, after which Leilani moved in with Bubba in the nearby city of Hilotoa. Bubba described her as a cheater and a liar and said she spent her days snorting cocaine and smoking marijuana. He said she would get violent, hit him when she ran out of money. She would sleep with other men to get cash for drugs. When Bubba was served an arrest warrant for breaking into the trailer, the couple got into a huge fight. Leilani admitted to framing Bubba. Bubba even questioned her if Quentin was his child, and if so, he demanded his name to be on the birth certificate. He insisted she slept with other men, and the two split. Police said Quentin was last seen by his mother's boyfriend, Youngkin, around 6 a.m. at their Savannah home. It wasn't until after 9 a.m. that his mother reported him missing. Bubba said the local sheriff's office contacted him the next day. He spoke to the FBI. He said the investigators were asking a lot more questions about her. They even had him take a DNA test to prove his paternity, which came back as a match. The next day, he stopped by Billy Joe's house to talk to her and Leilani, and added that the family was having a party and everyone was high as a kite and drunk as hell. He said Leilani was crying and was on something. Bubba then questioned her, how did Quentin go missing? How did a 20-month-old go walk out? She didn't have anything to say to me, he had. All she said was that she was sorry and that she didn't know what happened to him. That's all she does is lies, Bubba said. He was shocked that she had not been arrested yet. I can't believe she ain't locked up now, he said. She's a terrible person. She's going to jail or hell. She's evil. She shouldn't be here out in society, and if she didn't want him, she could have told me, and I would have came and got him. So that's Bubba's words. That's Bubba's words, y'all. I'm going to go ahead and drop the link for anybody that wants to come up and talk about the Leilani Simon case. I'm sorry, we were trying to watch the other one, but it's going to be a long one, girl. It's going to be a long one. And I am going to keep an eye out on the this Florida case, though, and see how it goes and how it continues, because they're at lunch break right now anyway. So we are going to keep an eye on that one, though. So if anybody wants to pop up and talk about the Leilani case, right now would be your time to do so. Let me go ahead and knock some of this stuff off. I have too much pulled up on my screen. But yeah, so the link is dropped for anybody that wants to come up and talk about the Leilani case and what you feel so far. The jury is out for deliberation right now. They rested their cases, so we're going to find out whether she gets, on the next couple of days, whenever they come back, whether she gets, charged or not. In fact, I'm going to make sure that over the day's time, I'm going to keep an eye on that. Because it can either go really fast or really slow. But both the defense and the state rested their case. So now all we're waiting on for that is for the jury to deliberate and come back on, sentencing and what they believe that she is going to get. Also, I do want to thank my new members, Tay Bay, Happy Life, and Jay Dunn. Thank y'all for becoming a member. But yeah, so we know that Henry Bubba, and I just read about Henry. Hey, Montrese. Hey, Miss Mitra. Good morning. We do know with that case and the situation at hand that Henry Bubba did go see Leilani, but hadn't seen Quentin in months. But they had a volatile relationship pretty much, right? They're saying that Leilani had a really serious drug problem. They said the grandma, Demas O, where you were talking about the grandmama, that she was doing shots and doing things too. So it's like, what with this family? I am researching and trying to see what's going on. If they are going to, she is, and the jury will decide on the 19 counts. Now she has a 19 count indictment. 19 counts, that's a lot for a person. Now Leilani did take the stand, but it wasn't to actually talk about it. It was Leilani took the stand, and then it was she basically said she wasn't talking about it. But we are at a recess break for the suitcase trial right now with Sarah Boone. We have, I'm trying to make sure I keep an eye on to see if when the jury comes back, what are they going to say about the Leilani Simon case? So far, I'm looking up. The jury has not came back yet. There's no updates as of right now, but the state did rest their case. So that means that we were waiting on jury deliberation. If anybody wants to come up and pop up, did I post the link? I'm over here like, oh yeah, I did. I posted the link. Let me go over here and pin it. So sorry about that, y'all. That today we were all over that case and I missed a lot of people. If you don't get to come up today and talk about it, we may even go back over this tomorrow, even though tomorrow's supposed to be Freaky Spooky Friday. We may actually go back over this case tomorrow. There's a reason why the Leilani case, because it is getting to become to where it's coming to an end, right? And so with it coming to an end, we know that they're fixing to come out with whether she's guilty, non-guilty, or what's going to happen here in the Leilani case. Now, in the court of public opinion, I do notice that a lot of people are, are leaning more towards that she's guilty. And so a lot of people are, and she, so we're just waiting literally on what's going to happen. We already seen that, the trial is concluded. So now we're just waiting on to see if she comes back as guilty or non-guilty. I'm so sorry, Demaso, that I didn't see your thing earlier. But if we don't talk about it today, that's okay. We'll talk about it tomorrow. But I'm gonna sit here and look about the Sarah Boone's thing. They're at lunch break right now. So we know that, but they just kept resting and going and resting and going for that. Let's see if we can find the resting arguments for the Leilani case right quick. To see if we can get some clarity on the Leilani thing. This right here shows, let me make sure it's where I can hear it. Hold on. So she didn't actually testify, which in her defense, if she had testified, that would open her up to where she could perjure herself. But, we're going to watch this right quick.
The evidence you shall give report on the issue pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ms. Simon, just have a seat on the witness stand, please. Okay. All right.
You want me to do it?
I'm going to start out with Ms. Simon. Ms. Simon, please state your full name.
Leilani Marie Simon.
Okay. And you're doing the right thing, just talking to the microphone so the court reporter can get it. I think you've heard me give that instruction a couple of times.
Yes, ma'am.
All right. Do you understand that you have a right to testify?
Yes, ma'am.
And that if you want to testify, no one can prevent you from doing so?
Yes, ma'am.
Do you also understand that no one can make you testify? No one can compel you to testify. Do you understand that as well?
Yes, ma'am.
And you have the right not to testify.
At BCG, beyond is where we begin.
The world has complex problems, and we're helping to find solutions.
BCG challenges me go beyond what I ever thought I was capable of. BCG.
If you don't want to, do you understand that?
Yes, ma'am.
All right. Do you understand that not your lawyer, but you personally are the one who decides whether or not you will testify?
Yes, ma'am.
Do you understand that if you do not testify, that upon proper request by you, the court will instruct the jury that your decision cannot be used against you.
Yes, ma'am.
In fact, the court will instruct if you decide not to testify. Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you choose to testify, you will be examined by your counsel and cross-examined by the assistant district attorneys in AUSA?
Yes, ma'am.
All right. Do you feel a need to have any additional time to consider whether or not you will testify?
I've been given plenty of time by my attorneys, notified weeks ago
All right.
about this.
Do you need any time to talk with him in private about this?
No, ma'am.
And so do you personally wish to testify or not?
I do not.
And with that, I find that the defendant, Leilani Simon, has decided not to testify with a complete understanding of her rights.
Yes,
Before you step off the stand, are there any further questions?
Just to follow up, is anyone forcing you to not testify or to testify?
No, sir.
Your choice is made freely and voluntarily?
Yes, sir.
Okay. And you've had adequate time to speak with me and Mr. Person about your choice, correct?
Plenty of time.
Okay, just have to make sure. All right, and that's the only questions I had, Judge.
All right. Ms. Simon, you may step down.
Thank you.
All right, so we know that the state rested their case on this. FBI analysts, they already said that Okay, so here's we are at the we're talking about where they said that there was a possibility of brain tissue tested for traces of different drugs, all of which were not detected. You may remember the defense questioning Leilani Simon's boyfriend Daniel Youngkin about whether Quentin or his siblings could have gotten into cocaine that was on the dresser next to the adults' beds. So they did not find drugs in Quentin's in his tissue. It says it said the test stained a pillow. They were talking about the you remember the pillow that had the stain on it with the blood in it? It was ultimately unsuitable for testing due to lack of material. There was also possible brain tissue. Dr. Kwizik tested for traces of different drugs, all of which were not detected. All of that was a result of clues in you reach whether this brain tissue contained any cocaine or any cocaine metabolites. I did not detect any. Okay, so negative, not detected. After visually looking at the pillow inside the pillowcase, I deemed it unsuitable for toxicology analysis, meaning either the debris or stain that was on there was too small or couldn't be analyzed. After lunch, a medical examiner from GBI took the stand as one of the last witnesses for the prosecution. When there's only bones, there's going to be a very limited ability to be able to provide enough information to say how a person passed. And Dr. Laura Darasol, forensic pathologist with Georgia Bureau of Investigation, Dr. Darasol testified Quentin Simon's remains were too damaged to tell exactly how he died, a fact that's been a sticking point for the defense. The defense cross-examined each witness in an attempt to discredit the data provided the jury. As their last witness, the prosecution called Detective Marina Lemons from the Chatham County Police Department back to the stand to show jurors a video that was taken shortly before Lillian Simon's arrest. Simon changed her dumpster story to say that she was throwing away 2 trash bags that night, not one, and not denying that she killed her son. Did Special Agent Solomon say you hid in the dumpster because you had harmed him in some way? Asked Tim Dean, prosecutor, Chatham County District Police Officer. She said that, replied Detective Lemons. And did she also fail to dispute the statement? Yes, she did. It's never in a never before seen interview police tapes. Lillian Simon claims that she doesn't remember part of the night. Prosecutors say she illed her toddler Quentin and dumped his body at the Azalea Mobile Home Plaza. It's almost like the light is on, but no one is home, Lillian Simon said in the video. She said the last thing that she remembered was looking at Quentin and then driving back to Azalea. Simon's defense team cross-examined Lemons for the first time. They asked about Simon's demeanor when Lemons said that mother's reaction raised initial suspicion. That was when you made your decision, correct? October 5th. Asked Martin Hillard, Leilani Simon's defense attorney. Decision about what? As to how and where you were going to focus your attention in this investigation. No, said Lemons. They closed out prosecution 8-day-long case against Simon, the defense saying there was not enough evidence presented to convict her on the murder charges and the concealing death of another charge. Prosecution and defense rest their case. As they Wednesday, Lillian Simon took the stand Wednesday without jury presence to say she would not be testifying. This comes after her defense team made a request to Judge Stokes to rule that there is not enough evidence for jurors to reach a verdict on the counts 1 through 4 indictment, which accused Simon of murdering her toddler Quentin and concealing his death. Defense attorney Robert Pursa said the state has presented theories and opinions, but nothing that establishes Simon's guilt on these charges. The state pushed back, saying their evidence is not speculation and points to an intentional act of violence towards Quentin. At this point, the state's evidence is grounded in speculation and grave suspicion, but not on facts, not on evidence. On behalf of Lillian Simon, we move for direct verdict of acquittal with respect to the counts 1, 2, 3, and 4 of the indictment. We presented sufficient evidence for the jury to find based on both circumstantial and direct evidence that the defendant is guilty on all 4 of those counts, said Dean. Ultimately, Judge Stokes, siding with the prosecutors, which means the jury will decide Simon's fate on all 19 charges. The defense didn't call any witnesses and rested their case. And after roughly 40 witnesses, the high-profile trial is now barreling towards closing statements. Court will resume at 9 a.m. Thursday morning, but the jury will be back at 10 a.m., and we are expected them to start deliberating at some point on Thursday. So sometime today, we've stated that the jury will be deliberating today on the Lillian Simon case. I am trying to make sure that we do not miss any of that. When the breaking news comes out, I'm going to make sure that I come back here. Even if I don't go live right now and I go live a little later today. Jay Dunn and Demas Ho or anybody else that wants to jump up on the panel at that time. Obviously, we're going to do that later. So right now I'm going to go ahead and I'm going to end this live because I've been here for almost 3 hours and I will be coming back later. When I get the thing, I'm going to add y'all on my community wall and y'all can let me know if y'all are free. If you're not, we can do it at a later stage. I hope everyone has a blessed day. And anybody who's sick right now, I hope you feel better. I'm going to go look to see, because the Sarah Boone trial, the Sarah Boone trial is still taking place right now. Court TV they're at lunch break until 1:30. So that's a thing that we note. I'm going to go ahead and stop this screen share right quick. And I'm going to keep an eye on the Lillian Simon case. And I'm going to go right now and see who is live on these YouTube streets. Lolo is live, y'all. Diva Tomboyish is live. Ness is live. Fulfillment Seed, The Good Putty Cat. Of course, Court TV and Law and Crime Network are live. Uppity is live. Room Shaker is live. Donald Goings is live. I'm going to go ahead and re-up that so I can make sure of that. And we're going to see what happens today with everything. Re-up that, just to make sure. Yep, it's still showing the same folks. So just make sure I didn't miss anybody. But y'all have a blessed day. I'll speak to y'all in a little while. I am going to come back as soon as we figure out what's going on. And Miss Mitra, if you would like to pop here, because I know you've been covering the case, we're going to figure out what happens with this. Y'all have a great day.
the T-U-B-E-L-O. I'm reppin' my hood, so love I'm gon' show from the T-U-B-E-L-O. I'm reppin' my hood to the day that I go from the T-U-B-E-L-O. I'm reppin' my hood, so love I'm gon' show from the T-U-B-E-L-O. I'm reppin' my hood to the day that I go.
I'm from the west side, we don't need no introduction, this was the best ride. We all big boy rolling and holding, come take a test drive. Hilldale, Evergreen, Glenkirk, Adder Street, bending every corner on the west, and that's where I'll be. Sunroof back, Captain C banging down 1800, chunking up the deuce to my post slanging down on 1800. Show no love to the ladies that's training round on 1800, making time stand still, crystalline swinging down on 1800. Watching out for them knuckleheads that be stanging round on 1800. Big rims and low pros be blanging round on 1800. Better completely change the way you're thinking about around 1800. Really hate to see you boys get left slanking around 1800. Out of street got some history, just let Captain C lay it out. If I don't finish it all on this one, let the second verse break it out. Remember the blue apartments from OG standing back there by 60 deep. Bull walking, saw blue, a big Anthony Hughes and Pee.
I'm from the T-U-B-E-L-O. I'm reppin' my